It turns about 70 years of shared governance on its head and dramatically changes how the executive and the legislative branches interact with each other in Wisconsin. And for some reason, most of their Wisconsin media outlets want to make this about a ban on conversion therapy for some reason. It's just odd the way the Journal-Sentinel and some other news outlets chose to cover this decision. But in a 4-3 decision, the liberals on the Wisconsin Supreme Court ruled a key legislative committee cannot block agency rules that are being put into place. Joining me now to talk about it is Rick Esenberg, the founder and president of the Wisconsin Institute for Law and Liberty. Good morning, sir. How you doing?
I'm doing well. How are you, Jake?
Real well. We haven't had you on the show for a while, so it's great that you're taking some time for us this morning. Let's start by explaining how there's a committee of state lawmakers that can block and overrule a Wisconsin governor's move or an agency move to implement a new agency rule. We don't have this sort of check on executive orders issued by the president and Congress, so it's a little bit of a different system at the state level.
Right. It's a different system, but it's the same problem. So, we learned in civics class that we have separation of powers, and this is critical to our liberty. The legislature makes the law, but it cannot administer the law. The executive administers the law, but cannot make the law. The judiciary can neither make the law nor administer the law, but it can interpret it and resolve disputes about its application. Mm-hmm. And so, but we found in, modern times when we ask the government to do a lot of things, that sometimes the legislature can't specify everything that the executive is supposed to do. And so it makes these broad grants of power and says things like, make rules for psychotherapists. And we need some way to check that. And one way would be to say that the legislature can't do it or they have to provide more detail before they do it. That's one way. The way that we've gotten to in Wisconsin over the last years, and I'm not sure that this is the best way to do it, but what we've said that, there should be procedural safeguards against the executive and its agencies making rules. Mm-hmm. And one of them is that the JCRIR, which is a joint committee of the legislature, has the ability to block these rules. And what the court decided, and again, and you mentioned that this isn't really a case about conversion therapy. That's one of the particular sets of rules that led to the case being brought. But If you read the opinion, there's no discussion of it. What they said was, well, you can't do that. The legislature can't block these rules because that would violate the requirement that the legislature enact laws by passing, by cameralism, by law passing two houses of the legislature, and presentment, that is the governor signing it into law. But that leaves the executive able to make laws without bicameralism and presentment, and that violates our separation of powers because it combines legislation and administration into one set of hands.
Right. And as you say, it's quite common, especially you will see this in Congress a lot, but certainly in state legislatures too, it's quite common for lawmakers to pass complicated legislation, and then it's up to the agency to put that into place. And these are instances, there are a lot of instances that we can talk about, including how the Government Accountability Board was being abused, where, the actual people at the agency level or the governor is not putting these laws into place as intended. I'm just going to steal from Brian Fraley here over at his Dairyland Sentinel piece because I think it's a pretty good explanation. He says what the court did yesterday is clear the way for politically appointed agency heads and their staff to implement regulations with minimal interference and oversight. Rules will now take effect unless blocked by the full legislative action. They'd have to pass a full bill through both chambers and have it signed by a governor to clarify or block an agency action. As a result, you have legislative oversight that's been diminished, and executive agencies gain greater autonomy to determine how these laws are carried out. He said, many fear agencies could outright ignore legislative intent until overruled by a lawsuit or new legislation. I think that's a good point. You could have agencies go rogue here, and unless the full legislature scrambles to pass a rule blocking them, and then gets a governor that might not agree with them to sign it, the agency can just do what it wants.
Right, and I don't think it's that they could go rogue. I think they will go rogue, because when you confer great power on somebody, it's almost guaranteed that they're going to use it. And here, what courts have generally understood for years is that this rulemaking by administrative agencies pursuant to some broad grant of authority from the legislature is a very, very constitutionally problematic thing. We have to restrict it in some way. And so we understood that when administrative agencies make rules, it really is to some extent an exercise of legislative authority, and that should give the legislature some power to check what it's doing. But here, I think the court abandoned that long-standing view of agency rulemaking, and as you point out, it reversed some very long-standing decisions.
So you don't agree at all with Jill Karofsky's writing for the majority that this, she claimed this is the setup is unconstitutional.
No, I don't, because I think what it leaves, and I think Justice Hagedorn did a nice job of pointing this out, what it leaves is an unconstitutional system. It leaves one in which the executive branch now has the authority both to make the law and administer the law without adequate procedural safeguards. It concentrates this power into one set of hands by removing the ability of the JCRIR to block the law. And that is a profound alteration in our separation of powers. And it's one, I think that the progressive left will come to regret. Groups like ours were, all about checking the abuse of executive power during the Biden administration. We said, look, the president can't unilaterally cancel hundreds of billions of dollars worth of student loans. And our friends on the left said, oh, no, the president can do it. And they said it because they liked what he was doing. Mm-hmm. Now Trump's in power, and truth be told, he's doing some of the same things. And all of a sudden, they're holding no king rallies. And this was a decision yesterday that was in favor of kings. As Justice Rebecca Bradley pointed out, it seems that our friends on the left don't like kings unless they're kings of their own making.
Yeah, you bump into my next question. We're talking with Rick Esenberg of the Wisconsin Institute of Law and Liberty. Governor Evers and his team, of course, celebrated this. They claimed, a handful of Republicans single-handedly stop and obstruct the agency, or the will of the people, as they always want to put it. But when the Democrats are in control of the legislature, they would have the same power. Isn't this going to backfire on them? When they retake, if they really think they can retake control of the legislature, but they might have to work with a Republican governor, they're going to be in the situation that the Republicans are in now. I wouldn't say could backfire. I would say will backfire because, I sound like a broken record. There are no permanent victories in politics. If you like Governor Evers now, I guarantee you there will be a governor in the future, say a Governor Tiffany, who you don't like. And that governor will now have the authority that the court handed it yesterday. And it's going to be very, very difficult, to get that back. I mean, the problem with Governor Evers' statements is that he thinks that state agencies are the body that are supposed to enact into law the will of the people. They are not. The legislature is supposed to do that. The agencies are supposed to do what the legislature tells them to do. And in part because the legislature has not fulfilled its responsibility of providing adequate guidance. We've tried to rein them in through this ability of the JCRIR to block rules. Well, we don't have that anymore, and so we've fundamentally changed the balance of power in our government, and not for the better. Yeah, I think it was Justice Rebecca Bradley. I think I've got this right, but basically, she was saying this seems to be like the third decision now coming out of this newly reformulated Wisconsin Supreme Court that's trying to restack the constitutional powers in favor of the executive branch. Well, right. They seem to be doing it because Governor Evers is, the Democrats or someone they agree with is currently the governor. Isn't this is just a feckless way for any court to work, but especially a Supreme Court? What, are they just going to reverse all these rulings when a Republican comes into office?
Well, it's a sore spot with me, Jay, because, I've had 3 of my cases reversed in the past couple of years, so I'm not quite over it yet.
Okay.
This wasn't one of them, but, there's a lot of that going on, and it's a long-standing goal of the progressive left. they have a great deal of faith in the ability of experts to run things, and so you elect a legislature, and then you sort of hand everything over to an administrative agency. But the problem is, and we're finding that out on the national level, is that Republicans can play this game too. Mm-hmm. And so I think it's quite ironic that at this time that we're all concerned, our friends on the left are all concerned about executive overreach on the federal level. They're quite fine with it on the state level. Mm-hmm. My advice would be, let's be concerned on it at both the federal and the state level. Let's follow the rules. I mean, I think our Constitution has worked very, very well now for 250 years, and we ought to stick with it.
I also have enough time here. I wanted to ask your thoughts, what your take is on last week's Supreme Court ruling that invalidated the 1849 abortion ban. Do you agree with the basic logic of the majority that, look, laws have been passed related to abortion since that basically negate the 1849 law?
No, because, I mean, again, this was another usurpation of power, this time by the judiciary. The key to answering the question that was before the court as to what happened with these laws that were passed during the time that Roe versus Wade was in effect is, what is the legislative intent? I think any honest inquiry would look at what happened, where you had a very strict law prohibiting abortion that then after 1973 could not be enforced because of Roe versus Wade. During that period of time, the legislature enacted a series of laws, placed limits on abortions which could be enforced with Roe versus Wade in effect, but they very intentionally did not repeal the older law. Now, I think you and I would look at that and they would say, well, look, I think their intent is clear here. Mm-hmm. They don't want to repeal the older law. Whether you and I like that law or not doesn't matter. The legislature didn't want to repeal it because they thought it might go back into effect someday when Roe versus Wade was overruled. Now that's happened, and the question is, what is the status of the old law? For them to say that this means that the old law was somehow repealed or limited to so-called non-therapeutic abortions, I think is to ignore the clear legislative intent. And even if I'm wrong about what the legislative intent was, the extraordinary thing about Justice Gallups' opinion is that she didn't even address the argument that I just made about what that intent obviously is. I think it was, whether you like the old abortion statute or you don't like the old abortion statute, it's a very concerning and disturbing decision.
I think you're right about what the clear legislative intent was at the time. You're the expert, I'm not, but I also don't know that we can just ignore a past law if we pass some other law that might be adjacent to it or related to it.
Yeah, two things about that. I mean, first of all, it is possible that these these laws that were passed in the Roe versus Wade era may have implicitly amended 90404, and that gets into, you're going to have to engage in a very thick analysis of how they fit together in order to see whether that's true or not. But the second thing is that it's not unusual to have a statute, to have more than one statute that prohibits a particular course of conduct and imposes different penalties. It's not ideal. I don't think it should be that way, but I don't think that the incongruity that leads to is, because it's not unheard of. I don't think it warrants a court to simply say that a law that the legislature passed and then, quite intentionally did not repeal can now simply be ignored.
Right. Well put. Well, and thank you so much for your time this morning. We got to run, but I do appreciate it, sir.
Thank you very much. You take care.
Rick Esenberg, president, founder of the Wisconsin Institute of Law and Liberty. It does fantastic work.